the webinar, where we'll be looking at certain issues facing directors during the crisis. The intention of the webinar is not to depress or be doom and gloom. It's simply to inform and to help you to navigate your duties during this crisis. Without wanting to come across as a shameless plug, I just wanted to mention that we have got some additional resources available on the FRP website that are free to download, with links to various information about principal measures introduced by banks, lenders, the local authorities and HMRC, along with some helpful downloads and a crisis toolkit, which you may find useful, or perhaps some of your clients might find useful. We are regularly updating that website, as I'm sure you can all appreciate. The advice and guidance is rapidly changing, and all of this can be found on the, as I said, on the website under the corporate resilience section. So on with the show, as they say. This is me, looking a bit more tidy than perhaps I do now in the pre-working from home life. My name is Phil Harrison. I'm a licensed insolvency practitioner and director in the restructuring and advisory team at FRP. I split my time predominantly between the Brighton and Portsmouth office, although currently I'm speaking to you from my bay window in my bedroom, slightly less glamorous. So what we'll be covering this morning: firstly, for those of you who do not know FRP particularly well, I will briefly give you an introduction to who we are, where we are and what we do. I will then cover the main topic of the webinar, which is directors' duties and wrongful trading within the context of the government's recent changes to those rules. And then finally, we'll go through my top 10 tips to avoid personal liability. And then, as Tracy has mentioned, we'll run a Q&A session at the end for those of you who are still conscious. So firstly, FRP started 10 years ago, and since then we have grown to one of the UK's largest specialist restructuring and advisory firms. We have 50 partners nationwide, 360 staff, and currently 18 offices UK-wide. As you can see from the map, we have a fairly decent coverage of the UK, stretching from Edinburgh down to the south coast. For the majority of our time, FRP has been an LLP. Until recently, we incorporated as a PLC and floated on the AIM market. So briefly, what do we do? The business is divided into 5 main service lines. Restructuring advisory, which is my specialism, is our core service line and where the business originally started. Over the last 10 years, we have seen rapid growth and added several other service lines, including corporate finance, debt advisory, forensic services, pensions advisory, to name a few. In addition to these services, the addition of these services has enabled us to better service our clients and accommodate the wide range of needs and challenges that they all face. So that was FRP. On to the main subject of the webinar. Much like the maligned Brexit term, if any of you remember that, unprecedented seems to be the new buzzword for the moment, overly used to describe the current events. But the simple fact is, it's true. No one has ever seen anything like this. And when it comes to advising businesses in the COVID environment, it's somewhat of a moving target and can be quite challenging. Having conversations about hibernating, mothballing, furloughing, and the suspension of wrongful trading provisions has previously been unheard of. In fact, I'd never heard of furloughing until this. As such, the responsibility of being a director in these times weighs heavy, and directors are faced with making important, often difficult decisions to balance the needs of their businesses, stakeholders and employees at a time of extreme financial distress. In normal times, if anybody can remember those, when we were advising directors on going concern issues and financial distress, we would group these issues into 4 key areas. Deteriorating results, i.e. declining sales, profitability, reduced order book, tight or breached banking covenants, and late or qualified accounts. We would look at balance sheet issues such as how long it takes to pay your creditors, how long it takes you to shift your stock and recover your debtors, and the usual one, crown debt arrears. We then also take a look at the operational issues the businesses face, i.e. if they've been gotten stopped by their suppliers, any legal letters or CCJs, and at worst, winding up petitions. Potential loss of credit insurance is a big issue, and of course, management spending most of their time firefighting rather than getting on with the normal course of trading their business. Finally, and fairly obviously, liquidity issues. So negative cash flows, breaching of overdraft or reaching the ceiling of your overdraft, agreeing time to pay with HMRC, particularly relevant at the moment, I imagine, and the inability to meet your debts as and when they fall due. However, I think it's fair to say at the moment, I'm sure some of you will agree with me, the biggest issue facing most companies at this point is the lack of cash. In many cases, the businesses we are advising are simply looking to cut their costs. I mentioned earlier furloughing, and where possible to preserve as much cash as they can to prepare for when we eventually come out of lockdown. We can all dream. When businesses finally reopen, they're going to need all the cash reserves they can get to get their business back up and trading as fast as possible back to normal levels. In addition to this, they'll obviously need reserves to start paying back some of the debts they may have accrued during lockdown. Before COVID, when talking about directors' duties, we would usually be advising directors about being careful when a company is technically insolvent. The coronavirus will not relieve directors of their statutory duties that they already owe to the company. Some of you may or may not be aware of these. These duties are set out in the Companies Act, which is an extensive document to go through. I've picked out the principal duties which are relevant to this webinar, which are as follows. To act within your powers, to promote the success of the company, to exercise independent judgment, to exercise reasonable care, skill and diligence, to avoid conflicts of interest, not to accept benefits from third parties, and to declare any interest in proposed transactions or arrangements. That's just a selection of them. There are many more. Whilst the company is solvent, the second duty in particular, which as a reminder was to promote the success of the company, requires directors to act in good faith and in a way that will benefit the company's shareholders. Usually, director shareholders are one and the same people. At times of distress, directors must be realistic about the company's prospects and act accordingly. Where the company's solvency is in question, the director's duties to shareholders will shift to a duty owed to the creditors as a whole. This sometimes comes as a bit of a surprise to directors. So what is insolvency? Insolvency is defined by section 123 of the Insolvency Act, if you want to have a look at it, as either of the following. Number one, when a company's liabilities exceed its assets, i.e. the balance sheet test. And number two, if a company is unable to pay its debts as and when they fall due, the cash flow test, which is probably more relevant at this point. If the company is technically insolvent, the actions taken by the directors will be under greater scrutiny, and in certain situations, the protection of the limited company status will fall away. And the directors may be held personally liable for any loss suffered by the company or its creditors. I would go on to say that there's an important difference between trading wrongfully and trading whilst insolvent, which is sometimes missed. Essentially, a company accused of wrongful trading will always be insolvent, but trading whilst insolvent doesn't necessarily mean that the directors are acting incorrectly, which should give some level of comfort. If the financial difficulties can be determined as temporary, or temporary in the eyes of the director, then it may not be unlawful. I do say may. There is a very subtle difference between the two. Wrongful trading, on the other hand, has statutory rules and regulations, and it is unlawful to trade if there is no hope of recovery. The clue's kind of in the title. This is important as when a company is technically insolvent, the director's legal duties move from promoting to the success of the company to preserving assets and protecting the interests of the creditors. Failure to do this can result in two very serious personal issues for directors. Number one, as I've already mentioned, they can become personally liable for the debts of the company. actions can be brought against directors for wrongful trading, fraudulent trading, misfeasance, and transactions with fraud creditors, to name but a few. Most of those, if you're acting in normal course of business, you won't fall foul of, but there are a few that you might do by accident. The extent of the personal liability aspect is usually by reference to the amount that the deficiency to creditors has increased after the date that the court finds that the director should have essentially ceased trading. So in addition to that, if that wasn't bad enough, if you're found guilty of any offences as mentioned above, or it's found that actors have acted incorrectly or irresponsibly, in addition to the personal liability for the debts, the Insolvency Service can have a person disqualified from acting as a director for up to 15 years. Now, at this point, it's fair to say that 15 years, you'd have to have done something pretty serious at this point, probably fraudulent. So it's rare to see that nowadays. The court can also order for a compensation order to be made against the directors financially to account for the consequences of their unfit conduct. So there's a double whammy there. Not only could you be potentially sued by a liquidator or administrator, but you could also find yourself being disqualified and also asked to pay additional amounts in compensation. All fun stuff. So the good news. Suspension of wrongful trading. So the government has decided that these are obviously not normal times, and it should give directors some level of comfort that the government has decided to suspend the wrongful trading provisions for an initial period of 3 months, backdated to the 1st of March, so up to 30th of June essentially. In effect, they are giving directors the green light not to pay landlords, lenders, suppliers, etc. for a period of 3 months, and therefore sanctioning directors to essentially worsen the position for creditors. Some of you will be creditors of other businesses as well, without the risk of wrongful trading action, should the business then subsequently fail. And that's an important note to make, that these provisions only come into effect if the business fails, essentially, and goes into an insolvency process. I'm playing a bit fast and loose with the term interesting here, but it'll be interesting to see if the provisions are extended any further in line with the extension of the lockdown. I think I saw on the news this morning that Boris will be mentioning it at some point today, what his plans are for the lockdown period. So we'll see what happens there. It's important to note that the government hasn't suspended it has suspended wrongful trading, but it hasn't suspended fraudulent trading, misfeasance, breach of fiduciary duty, preferences, transactions under value, and the plethora of other claims that can be brought against directors. Therefore, directors are not fully protected from the claims being brought against them for decisions they make during lockdown, particularly if they are found to have acted irresponsibly and in breach of their duties. So really, the wrongful trading provisions, whilst it's helpful to a certain extent, you certainly cannot rest upon your laurels as a director as far as how you transact with people. So all that was a bit doom and gloom, I'm afraid. So onto the bit that you're probably more interested in, and that is how can directors protect themselves from potential future criticism, potential personal liability, and disqualification. Firstly, act in good faith. If the business has no income due to being forced to shut down by the government interventions, they're not paying landlords, suppliers, etc., is not unreasonable in the circumstances. However, if the business is largely unaffected by these interventions and is maintaining a reasonable revenue stream, then COVID should not be used as an excuse simply just not to pay people. This is quite an important one, and something I find directors fall foul of quite regularly in an insolvency event. Salary versus dividends. It's not uncommon for directors of owner-managed businesses to be remunerated by way of a small salary below the tax threshold, supplemented with drawings that are offset by declaring dividends, usually at year-end, sometimes during the year. This is a common and tax-efficient way for directors to be remunerated. However, where it becomes risky for directors is when the company starts to struggle and enters into an insolvency event. Drawings are treated as loans from the company. In practice, a director may draw a regular tax-free amount each month later declaring a dividend at the year end or at interim levels during the year. And this in itself is not wrong. But to declare a legal dividend, there must be distributable reserves available to the company. You must have board minutes approving the dividends, and dividend vouchers and interim annual accounts are needed to be produced each time a dividend is declared. In fact, actually, Colin, at the end of this webinar, you may be able to back me up on that. So let's paint a scenario. Company enters into liquidation halfway through the financial year and has declared interim dividends prior to the insolvency. No management accounts are prepared, and therefore there is no visibility on whether the business is profitable. As part of the statutory obligation to investigate the directors' conduct, the liquidator reviews the dividends and claims they are illegal and therefore void. The effect of this is that the director's loan is therefore reinstated to the position it was prior to the dividends were declared and is repayable to the company / liquidator. In his defence, and not unusually, the director claims that he was acting on the advice of his accountant and he should not be held accountable. And it is not unreasonable for a director to rely upon the advice of his professional advisor, who in turn has provided the appropriate advice relevant to the circumstances at that time, which is usually when the business is first set up. However, a director owes fiduciary duty to the company and is therefore liable to repay the loan. Unfortunately, even if the loan is repaid in part or full, the story doesn't end there. The authorisation of unlawful dividends may also be challenged as a breach of your fiduciary duty and may lead to a potential misfeasance claim. In addition, if the correct paperwork hasn't been filed, HMRC may challenge the payments as salary rather than dividends and require NIC payments. So essentially, you're paying tax anyway. Other considerations that the director can miss out upon. When the company enters into liquidation, the government will pick up the tab up to certain statutory limits for employees' entitlements, including arrears of wages, holiday pay, notice pay, and redundancy pay. Currently, the weekly limits are £538 a week. So what about our poor, battered and bruised director? Surely at the very least he can claim his full entitlements as an employee at this point. Well, unfortunately not. If the government considers they can claim at all, and this is not guaranteed, particularly if you're a director shareholder in a business, the government will only repay their entitlements based on a minimum wage as per the payroll. This could be significantly less than what he may have been entitled to if he had been taking a salary rather than dividends. In summary, at a time where businesses are their most stressed, it will be prudent to look at the basis for how you are remunerated and speak with your accountant about mitigating your risk to the above scenario. Paying a little bit of tax may be preferable to finding yourself on the wrong end of multiple claims that can equate to tens of thousands of pounds in some circumstances. And at the end of the day, you can always change the basis for how you are paid once the business has stabilised. Deposits. Now, this is a tricky one, particularly if you're relying upon deposits. But if the board is not certain that they can provide the product or service, deposits must not be taken from customers. If you are taking deposits, and it cannot be avoided, then the deposits must be ring-fenced into a separate account away from the usual cash flow of the trading business, and only released into cash flow once the service or product has been provided. I mentioned earlier in the webinar that there's potential disqualification proceedings that can be brought, and one of the main things they will look at is if you've taken customer money and used it for normal cash and then not provided the service. So you have to be very careful with that. Implement good management practices. So insofar as possible, directors should have access to up-to-date financial information, which should include a crisis management plan for the next at least 3 to 6 months of disruption to demonstrate a mid to worst case scenario. The effects of the pandemic on businesses will be long lasting, so directors should also have a post-COVID survival plan for perhaps the next 2 or more years, not just the next few months. In consideration of implementing an effective long-term procedure, you should include the production of detailed, accurate and up-to-date management accounts. The crisis plan and suitable management information should be regularly reviewed so directors can consider whether the company can continue to trade. So it's all well and good preparing this information, but it must be regularly reviewed and updated. Regular review management accounts and all other relevant trading financial information. Document key decisions or reasons to continue trading. This is really important and often missing. If you are deciding to pay a creditor over another, you must document that somewhere. It doesn't have to be an extensive board minute, but it just needs to be documented somewhere. As if eventually you do enter into insolvency, you'll be asked to justify why you essentially preferred one creditor over another. Monitor the position of the company's creditors to ensure that their positions do not worsen. And expedite debt collection. This might be tricky, considering that most businesses are all in the same boat at this point. Avoid transactions outside the ordinary course of business, whatever that might be now. Directors must avoid allowing the company to enter into any transaction outside the ordinary course of business, which may have the effect of preferring, just as I've just said, any creditor over others, particularly if you've given a personal guarantee to that debt. So you can see a scenario where it might be tempting to discharge a debt where you are personally liable for it. But in the event of insolvency, that transaction can be reversed and you can be asked to pay it back. So you must be mindful of those. It's also an offence. Obviously, going forward, the question might arise as to what the ordinary course of business actually is during this crisis. So it's a subjective test. This might be teaching you to suck eggs at this point, but as I'm sure you already are, but it's really important to engage with your stakeholders. So to discuss your strategy and document all critical decisions taken, in particular the decision to continue or cease trading, and the reasons behind these decisions, together with supporting financial information. Ensure that you communicate regularly with your various stakeholders, including shareholders, employees, lenders, and suppliers, to inform and reassure them of the steps being taken to implement your crisis plan, so as to ensure that business can continue to trade, and if necessary, manage any messages where there are difficulties in providing business as usual services. I think it's fair to say at this point, and I'll be interested to hear from you guys as what your experience is at the end of this, but we expect lenders and customers and suppliers to generally be supportive at this time. So regular engagement with them is extremely important to maintain your goodwill with those particular entities. Utilise any of the government support that's out there. So I'm not going to talk about any of those particular products in any detail, but as we mentioned, furloughing staff, applying for CBILS, deferring tax, and utilising time to pays with HMRC, who have also been handed down an edict to be a little bit more lenient on people than they perhaps would have been prior to this. Just a quick word of warning though. Except for the grants, the payments on these support packages are only deferred. So you should take a long-term and prudent view on whether the business can realistically repay these debts when they eventually fall due before making the application. Taking on credit where you know there's no chance of actually repaying it can be considered a breach of your fiduciary duties, misfeasance, etc., etc. So it's not simply good enough to apply for the money and then hope that it's going to see you through to the end. Following on from that, just keep up to date with everything that's going on. So progress with easing the lockdown and government assistance is rapidly changing all the time. So keep up to stay ahead. Take professional advice. Directors should obtain more importantly, act upon professional advice and consider undertaking basic contingency planning. So that the directors understand the position for creditors if the company should enter into insolvency process. Directors should consider other processes that might be available to the company, including administration, company voluntary arrangements, and voluntary liquidation, and the likely outcomes for creditors for those processes. Best timings for the company to enter into the process in order to maximise value and mitigate loss to creditors. I only include that in there because it might be obvious that I would labour this point, but there are certain processes that are available that are rescues and are available to and perfectly acceptable to use at times of distress. more importantly, it's a springboard to, if you take the advice, it's protection from you as director, that you have considered the options and it justifies the actions that you then take later on. Even if the plan doesn't work, you've got something on file that says, I took the advice and it simply didn't work, or it did work, whatever it might be. And finally, it's a bit of a cheat, this one, but did I mention that documentation is key to everything? So I cannot stress enough the need to document your reasoning behind making key decisions, particularly where it affects other stakeholders, particularly if you're choosing to pay one creditor over another, for which there are perfectly good reasons to do. It will be too late if you find yourself trying to defend a claim against you if you haven't got written advice at the time that you made those decisions. So that's me done. I'm sorry if it came across as a bit doom and gloom and a bit scary. The purpose really is to inform you, to help you navigate what is quite a difficult set of circumstances. And I'm available now to take any questions anybody might have.
Lovely, thank you very much, Phil. I'll get Lauren to unmute everyone, and then I know we've had one question from Paul, so I'll go to him first, and then Leon, I'll come to you after, if that's okay. So Paul, do you want to put your question to Phil?
I can do. Well, I've written it down there, but I've given a deposit to somebody. The event now won't happen because of coronavirus, so I haven't cancelled. The world has, effectively. Obviously, I want a refund. They want to supply a credit note, in other words, roll it forward to some future booking. Mm-hmm. Obviously, I'm nervous about being an unsecured creditor if they go bust.
Yep.
And I don't want that because I know how much I'll get, which is nothing. And so I just want to know what the law is. What is the law? What does the law say about what I'm entitled to and what I'm not?
Good question. So, you know, one of the things we need to look at is what the terms and conditions you signed up to in respect to that particular transaction. So there may be some, there will be a crossover between insolvency advice and legal advice as to what your rights are, as far as if the terms and conditions state quite clearly that if you pay a deposit and the event can't take place, that you will receive a credit note and that's it. You may need to take some legal advice as to whether that's enforceable. You're right that if the business goes bust, you will be treated as an unsecured creditor, and depending on the time they go bust and what assets they have, as you quite rightly say, that you may receive nothing as a result of that. It may be not something you want to answer directly on this, but how you paid will also have an impact. If you paid by a debit card, it's unlikely there will be a recourse to the bank, although some banks do have that ability on their debit cards. If you pay by credit card, then you may be able to actually reclaim your deposit through the chargeback scheme. So that may make a difference. So yeah, in summary, really, it's checking those terms and conditions. And you know, most businesses where they have taken deposits and are looking to roll them forward are obviously looking to preserve their cash position. But actually, if you put in form writings like, no, I don't want the credit note, I want my cash back, then that will be the first stage, and hopefully you'll be able to reclaim it. But check the terms and conditions to see what you're able to do.
Lovely, thank you, Phil. Leon.
Hello, Phil. Thank you for that presentation. That was very enjoyable. But really? Seeing I've been watching YouTubes of how to paint fences and things like that. Yeah. You didn't have a lot of competition, but no, very good, very interesting. My question for you really is, I'm an accountant, and what I have done with each individual kind of business is have a look at the latest bit of information we've got regarding their accounts. So it's probably most of the time it's the latest filed accounts. A few of them there's some management accounts, but on the whole it's, as you know, small businesses, it's all kind of latest filed accounts. Yeah. And where obviously you know, I've got a client who's got reasonably good reserves in the company, then I haven't changed anything regarding their salary. I've just suggested to them that they carry on as normal, as you mentioned, the basic minimum salary, and then they can take dividends because they've got the reserves to do so. Mm-hmm. What my question is that I have a couple of clients who because they are in an industry, for example, like tourism or anything on that, hospitality, that kind of business, their income has totally stopped, but they have got reserves, so they have got money in the bank account. So my concern with them has been them making, as you mentioned, illegal dividends. So what I've suggested to them is that they take a higher salary at the beginning of the this tax year, because we've now just got into April, the beginning of the tax year, because they're on cumulative NI directors pay. The national insurance only kicks in once they hit the threshold. It does actually generate a little bit of a PAYE liability. But the idea is that for the 3 months they have a high salary, and then after that, on the basis that they can continue, then we would just really reduce the salary, and that'd be backed up by dividends. And so the PAYE liability at the end of the year will be zero as normal. But if they take a higher salary, and we'll just say, for example, 2,500, if they take a higher salary, they're only going to get furlough payment of about 576. But as long as they justify the reason that they're taking the salary, i.e. they're taking a market salary, how would that sit? I mean, I'm getting to do minutes because obviously the potential of you mentioned about making decisions. I'm quite into getting everything documented, especially when there's an element of risk. But I was just wondering, how would that sort of sit? The fact that they may have taken, let's say, 7,500 in salary in the first 3 months, and then they go, let's say they do get liquidated.
Well, it sounds to me like you're doing absolutely everything right, so that'll be a relief. Because you're absolutely right. We touched upon in the presentation that drawing dividends at a time like this is probably ill-advised unless you're sat on a pile of cash and you can demonstrate in your financials that the reserves are available. So it's not wrong to do it as long as you have the reserves. And actually strategically putting them on the payroll in order for them to pay just a marginal bit of tax, but to give them the comfort that if particularly they're in at-risk sectors that you talked about, if they do go bust, quite often directors will find themselves, with a not an insubstantial set of drawings that they can't offset against dividends they were planning on, and there's not a great deal that can be done about that. The liquidator will look at it and say that has to be repaid, in full or in part at least. So I think you're absolutely right in putting them on the payroll. If it's market rates, then again, I don't think that can be challenged. If obviously they're going on salary for 100 grand or something like that, that's a bit racy. But if it's for market rates, they've got the minutes to back up their decision making behind that, then I can't see how that can be challenged.
Oh, great, thank you. Yeah, it's a difficult one for for everyone, and one of the first things I was concerned about was obviously the wrongful trading. Having been an accountant in practice for a few years, you had a few cases that have sort of come across your desk and you've been aware of. And the other thing I was just going to say that I've sort of suggested to people was the furloughing. Is that they look at Section 172 of the Companies Act, of what your director's duties are, because I think a lot of people seem to be a bit unsure if they can furlough as a director and what they should be doing and what they shouldn't be doing. I was just wondering what your thoughts are yourself on that basis.
Yeah, well, a lot of directors are essentially employees, aren't they? Sometimes it's just them. So the directors do wear a lot of different hats, which can make making decisions quite difficult because you're constantly switching hats and roles. But I have seen directors furloughing themselves, and it seems to be perfectly acceptable and quite right, because it's no different to furloughing another employee. So I don't see anything wrong with that.
Okay, thank you.
Thank you, Leon. And Phil, well, we have a question. Neil Budgeon has a question about directors' loans. Neil?
I've actually got two, but the director's loans ones, yeah, you were hacked through an awful lot of material this morning. Thank you very much. Currently, my business has 4 shareholders and 3 directors, two of whom, 2 of the directors, myself included, are funding all the R&D. So the company basically, its income from is extremely low. That's not a problem for us. Yeah, we have a fairly large personal budget to bring a new product to market. And this has been done via director loans. However, on a couple of occasions in the last 2 years, both myself and the other shareholder director who've been making substantial payments into the company have withdrawn money under the fact that it's a loan. So I've got a hearing deficiency, and just when it was critical for me, you zoomed across that bit quite fast. So I was just looking for clarification that, I mean, our only likely exposure to having been taken out of business is if we somehow managed to get into litigation that was beyond there. We didn't wish to fight it for, that's the only way we could be taken down, because we're not trading. We've got a budget, bunging it in, developing a product. So loans have been put in, and so on at least 2 occasions we've taken money out that could be personal. The use was suggest. Well, I thought I heard that you were suggesting that could be deemed not kosher by one means or another.
No, not necessarily. And I think this might be, as it's business specific, it might be something that we better chat about after the webinar separately if you want. So I can certainly have a call with you separately about it, as it's quite specific to your business. If you didn't want to share that on the webinar with everybody else, but
shall I do it?
More appropriate to do that.
If I do an introduction email to you both.
Yeah. Would you like to do that, Neil?
The other question I have is one of general interest, although there is a definitive case here, that I left the business a couple of years ago because I decided that it was trading insolvent situation, and I didn't wish to continue to be a director under those circumstances. The main director assured me that he had spoken to his accountants and financial advisors, and he wasn't trading insolvently. I've never been able to understand that, because I knew personally of it was a very small company. I was a current creditor, not paid under my terms. I knew the 2 other creditors to the company had not been paid. I mean, we all knew each other very well, and the only conclusion I could come to was, because we were all very pragmatic people and knew that we couldn't be paid. It wasn't a question that the guy was choosing not to pay. He didn't have any money. The company didn't have the money. So the reality of the situation, everybody accepted that their terms. And whilst I've never seen I asked for but didn't receive a written statement from the company's financial advisors as to how they came to the conclusion that the company wasn't whilst insolvent, I never got that, which is another reason that prompted me to leave. But I've never been able to understand how one could sit there and say, we're not insolvent, paying our bills. Could you throw any light on how you could possibly argue that the fact that we can't be, a bunch of creditors can't be paid on time and have accepted that situation, could result in being able to stand there and say that you're not insolvent?
Well, it's all on a case-by-case scenario. Really, all the facts turn on their own merits. So it's difficult to generalise as to whether one entity is insolvent without the detail. But generally, in one of my earlier slides, I set out the kind of the 4 key areas that we look at to establish whether a business is insolvent. And I think the Chamber will provide the slides to people as well, so you can have a look at those in detail. But in addition, there's the two tests, the cash flow test and the balance sheet test. And it's how many of those boxes are ticked will demonstrate whether the company is either temporarily insolvent and it's working through its problems with a view to returning to profitability, or whether it's completely hopeless and actually there's no way it could not be, you could continue trading insolvently. And really the risk for the directors is how long it takes to reach that conclusion. And that's where the wrongful trading provisions kick in, because at the end of the day, if you've been trading for the last 12 months when there was absolutely no hope at all and the writing was on the wall 12 months ago that the business was hopelessly insolvent and couldn't be turned around, then that's when you're at real risk that the liquidator or administrator is going to look at you and go, you should have known back then. And any reasonable person should have known back then. And as a result, the creditors' losses have accrued. And you're responsible, Mr. Director. So that's when you find yourself on the wrong end of a claim. So establishing insolvency is not a straightforward process, and it requires looking at a myriad of different factors to establish that insolvency. So I don't know whether that answers your question.
No, that does actually. I can see how, and knowing the person very well, I can understand that. Yeah, he used all possible reasons to agree with his position, even though I say on paper the future cash flows would mean he couldn't be solvent. He wouldn't be able to pay the three creditors for something like at best sort of 3 to 5 years without one particular order coming through which hadn't materialised in 2 years and now hasn't materialised in 4. But yeah, I was interested in I mean, I don't disbelieve the guy. I've known him for 20 years. When he says he spoke to his accountant, I believe he spoke to his accountant. When he says his accountant advised him that it was okay to carry on, and I wasn't able to see that in writing, my take on the guy was, well, yeah, it was how he read what he chose to read into it. It's a very small company, so the chances of anybody doing anything about it, so we're all pragmatists, is it? There's no point in going down the debt collection route if there's nothing to collect. The company's assets are not realisable, too specialised. They'd sell for scrap metal rates. I mean, it's not going to pay back 30 grand for the creditors. But yeah, I was interested in how a professional advisor could give any information to that extent. And I was assuming that the mistake I've made, and you've clarified it, is that I took that the creditors as they fall due to be one test, end of, that's it, you're either in or out.
No, there are a few other tests that you need to look at. Yeah. So
if I just jump in there, because we're just kind of approaching the end of the session. I just want to see if hopefully, Neil, that's answered your questions, and anything else I'll introduce you to Phil via email, just to see if anyone else has any questions, any other questions that they would like answered before we sort of approach the end of the session. No other questions? Oh,
sorry, I may just noticed the top share button.
That's fine. I thought everyone had gone then. It's like, oh my goodness. There's no other questions in the chat. So I know, Phil, there's been a couple of requests to share the slides, so hopefully that's okay.